Welcome to today's episode of Unthinkable, a podcast about the aftermath of incidents causing catastrophic injury or death, the experts who are called to serve when these accidents occur, and lessons that we can all learn and implement in our own personal lives. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, kylebachus.com. Now, here's the host of the Unthinkable podcast, Kyle Bachus.
Hey, everybody. Kyle Bachus here. Great to have you here for another podcast where we're going to do some investigation into kind of the behind the scenes of what happens after a catastrophic injury or death case. As you all know, I'm a lawyer. I've been doing this for almost 30 years. Been helping injured people. Had the same tragedy happen to me, where my mom was killed when she was run over by a concrete mixer truck. And I got to see firsthand my family's perspective on what it was like to be a victim and when something that awful happens to you. And so I'm in an incredible space with an opportunity to both represent families and also understand what it's like to be a victim. And we want to offer insight to those of you who may be going through it and also might just have an interest in understanding what is undertaken as an investigation after the unthinkable happens. So I have a terrific guest today, one of my good friends, Aaron Evans. He is a managing partner at Evans Case, a terrific law firm, probably the best in the entire region, the Rocky Mountain region, and maybe one of the best in the United States of America, dealing with probate and estate issues. So Aaron, thank you so much for joining us today.
Yeah, of course. I'm excited to talk about it. It's an interesting area.
Yeah, it is very interesting. And I think some people might ask, well, as an estate and trust probate lawyer, first of all, before we get into the role that you play and lawyers like you play after a catastrophic injury or death, and giving some life hacks so that other people can kind of be prepared or prepare their family in the event that they suddenly lose somebody. Can you just talk about, how you got into this field and what you do day to day as a lawyer in the field of estates, probate, et cetera?
Yeah, my firm when I started here used to actually be called Thomas Quinton Benton and Associates, and Tom Benson did a lot of estate planning. So when we started doing that, the probate side came from people that were clients and then would pass away, so family members would call us. And as a firm now, we have 10 lawyers, and all we do is estate planning, probate litigation. When I say elder law, that means guardianships, conservatorships, and litigation related to those, contested, uncontested matters on that. So it's really become something that I'm proud of because it is a very specialized area of law. And I feel we do one of the better jobs in the state as to helping families through that process. It's not easy. It's complicated, and there's always something that's got a little wrinkle into it that makes it a little bit harder or unique or just some way to navigate through the probate process.
So, it's interesting. We come into contact in my practice with families who have suddenly, they're suddenly confronted with the loss of a loved one who has been, they're here one day and they're gone the next day. And the family is faced with a whole bunch of issues, related to accountability, which we help with. But they also are suddenly thrust into a situation where, does my relative have a will? What does that even mean? And in looking at just the sudden loss of somebody, being completely either very unprepared or some are more prepared. Can you just talk about the very first instance? I'll have to have a conversation, and the family will say, I'll say, well, do they have a will? What does it even mean to have a will, and what is a will?
Yeah, it's often funny in the sense of how many people don't have wills, which isn't the end of the world. But a will primarily is a document that states two things. I think they're the most important. One is who's going to be in charge, right? Who your personal representative, who is your executor, who do you want to be in charge of your estate? And then the second thing is who gets your estate. that's always something that's important, to state your wishes. And I think it tends to help family members understand and respect what you wanted versus intestate, which is if there is not a will. So we see all sorts of wills, which can be your normal, what we call self-proving will, which is a document that is signed by the testator, has two witnesses, and notarized. So that would be your standard will, which would set out who's going to be in charge and what happens with those assets. What can happen a lot is people have minor children. And if a minor child is to inherit some money, your will would state that it's to go to them, but it would most likely also include who's going to manage that money for them. Because if they're under the age of 21, you cannot inherit money directly. So it has to be put into a protective account, let's say. If the will doesn't say anything, it would go into a conservatorship for the child until they're 21. But most times, if you've done a will, that will sets out when you get the money. So it may go into what we call a trust. It's called a testamentary trust because the trust is really just created by the last will and testament. That trust then sets forth what happens to the money for the minor children until they're a certain age. An example in my will with my children was they get a third at 25, a third at 30, and then the final remaining third plus interest or whatever at 35. The example we give when doing estate planning with clients is kids that are that young don't make good decisions with money. Example I gave is I had a friend who lost his dad when he was young. He inherited some money at 18 back in New York. And the first thing we did was go to the mall and buy a big stereo, right? I mean, that's what kids do with money, right? They think in the 5 minute range versus 5 years. So wills can help on that because it does say that the money's supposed to be protected. That means you avoid the necessity of having to file for a conservatorship because that's a whole other action that you'd have to do. Otherwise, if the will said there was a trust to be created, you would avoid that piece. So, if
So,
there,
so let me ask this just generally. Are there any stats out there of what percentage of people actually have a will? Because anecdotally, I would bet that of the families that end up in our office, I don't know, man, 20% maybe actually have a will, and
I
80.
would say what I've heard is 30% is usually that have a will. I mean, which is crazy. And then what happens is you get people that do wills that are not really self-proving, right? Colorado allows for holographic will, which is a handwritten will, which you can even do, is just simply in all your own handwriting, write it out and sign it and put a date on it. And that most likely will be a valid will. Um, they may get contested, so it's not the simplest issue, but there are other things. And there's actually a statute in Colorado that allows for writings intended as a will, which can be something unique that you just put together, which happens fairly often as well. So there's ways around it. But yeah, I think what you said, the majority of people don't do anything for whatever reason, because it is a tough conversation about your mortality. That's
And
something to
so uh,
avoid.
an actual will is me writing something down, like you said, like a real will. And you talked about some exceptions. I want to go over those briefly again, but a real will, like a valid real will, is what you write it down and then you have a
Two
couple of
witnesses
witnesses.
and a notary is what's called
Okay.
a self-proving will in Colorado. So that would be admitted to probate without any question. Um,
Okay.
and that
I took estates and trusts in law school. Now I think I got a B plus in it. But that was 1990. Is there something about when you make a will, nobody who stands to get something out of the will should be a witness to it?
That's
Is that
correct. It
an
should just
issue?
be disinterested parties. A lot of times, if you're using a lawyer, the lawyer will have people in his firm that do the witnessing or notarizing. But yeah, it should not. It should be a disinterested party.
And so then you mentioned something. So that's what a real will is. And then you mentioned something called a holographic will. What is that? Is that like a hologram? What is?
A holographic will is when somebody writes out their own wishes in their own handwriting. So basically, it's almost like writing a letter, that states, and there's no real perfect language to it. It just says, here's what I want to happen and who gets my assets. And we see those fairly often where somebody just hand writes out what their wishes are, what they want to get done. And that will, again, you'll have to go through formal probate, which is a little bit of a wrinkle. But that's basically it.
So if it's just somebody writing out their wishes, how do you have to prove then it's actually their handwriting, it's not somebody else's who just decided to write it up after they died?
You don't have to prove it. What you do is you put it out to the heirs related to the person who died, and those heirs or people that are his like family members, let's say, which should normally be maybe parents and children, potentially siblings, would have an opportunity to object and say if they didn't believe it to be a valid will.
Okay. Yeah.
So that's so they get notice. They get an opportunity to say, do we agree this is his or hers, last wishes or not?
Well, another thing that we see is a family will come in and we'll say, well, do they have a will? And they say, I don't know. We never talked about it. And I didn't expect them, they're 40 years old, or when I didn't expect them to die. There was no illness. And so I don't even know where to begin to look for the will. Let's say you did a will, like you described a real one, or you did a holographic will. How are you supposed to make sure people know where to find that if something happens to you?
Normally, if we do them, we keep a copy. We email it. You just try and encourage people to put it with their important documents, right? I also tell people, because a lot of times think of a will as dealing with bigger assets, right? Like investment accounts, real property. So a personal property memorandum is what you put to state what personal property you may want. Examples of that could be a car, jewelry, things like that. You state that you want them to go to a specific person. If it's not listed, then the will usually has a catch-all that says everybody else gets what they want or not.
Okay, it's really interesting. So, in terms of where somebody would save a will, uh, to make sure that their family can find it, what are your recommendations on that front?
These days, usually it's a safe that somebody has, or if they have a file with deeds or anything important. I would say this, and I meant to say, I think it's also important for people to put with their will important other information, and I mean by that, passwords, access things, right? Facebook could be a good example. Is it's very hard for someone after, or Apple passwords. It's very hard for someone after someone died to get control and access to that information. So we encourage clients to put together a simple one-page sheet that just says, here's my Apple ID password, here's my Facebook password, here's the code to get onto my phone, right? It's very difficult for someone to be able to break into that without having all that information. So
Well, I mean, it's a great point, Aaron, because even in my own situation, my mother, she was like the historian of our family. She had so much on this Shutterfly photo account, and we were really lucky in a sense that she had been working on and had it opened on her computer at the time that she went out for a walk that she never came back from. But we were able to go in and get access to these photos, and it just is. It's very important information because the access to these online accounts is maybe everything, right?
it is, and you have no ability to get, they want to have an email to reset the password, and if you don't have access to their email, or like all we see now is how when you try and log into bank accounts, things like that they ask to text your phone, right, to get a code. So it's very important for people to at least make sure they put all that together somewhere, even if it's a note that they share with their family members, say, hey, here's all my access information. Because getting access, even though you may have somebody get appointed in the probate process, it's still very difficult for that's called the PR, the personal representative, to get access. Even though they've been appointed, that doesn't make it that much easier as compared to just having a little bit of information that can go a long way, and them getting control and helping out with all the things, photos,
Yeah.
it's interesting things.
Yeah, really, really important. So let's now talk about the 70-80% of people who don't have a will, just so people understand. If you die without a will, there's a name for that. It's intestate, right? That's what
Yes. Yeah.
and that's a legal term. But what happens if you die without a will? You know, who gets what?
Yeah, there's a statute that sets out intestacy for anyone. Usually, it goes to spouse. If no spouse, to the children, or spouse and children will share. There is a statute that within that statute as to second wives, or second spouses, I should say, because then the spouse will get a different percentage comparatively to the children being his or her children or not. And if there are no children, then it goes up to parents. If no parents, then to siblings, and then it goes out that far. So usually within there, you find somebody or someone that can handle it. And at that point, that the priority for who will be the personal representative tracks the same statute. So, except for minor children, they would never have the ability to serve. It can be a family member then serving. And then the inheritance is the same thing. So it's pretty straightforward as to who gets what, but it really does complicate things for family members because there becomes the fight of who wants to serve. Right. And there's still a lot of people that believe I'm the oldest child, I should do it. But there's also children that might have been living with the parent or sibling and helping. So sometimes that creates litigation that could have been avoided if there was just a will to say who you wanted to be in charge.
And if you die intestate, you're losing complete control of who gets what. The state in this statute or law is dictating who gets what. Is that
100%.
right?
Yes.
And so let's say that somebody dies and they have a will, or maybe they don't have a will. Um, how do you actually transfer the property itself? Let's say it's a car. We'll talk about a house too, but I mean, just walk through. That's great. So I have a will, or let's say I'm the person who's supposed to get the uh, the the estate, as you call it. And estate just means the stuff, right?
Yep.
Is that so? I'm the guy who's going to get everything. How do I actually get it? How do you do that
Yeah.
legally?
So you file for probate. I'll say this for simplicity too. If the estate is under, I think it's 84,000 right now, you can use a small estates affidavit, which is simply a document that is signed by whoever the rightful heir is. Let's say if somebody dies and they're not married and they have no kids, it would go to their parents. The parents would fill out the form and say, we're each entitled to 50% of our son's estate. You take that and go to like Chase Bank, Wells Fargo, with a death certificate, and the bank will just pay out those accounts that are under the total of 84,000. That's as
Well,
simple
that's a
as
great option, right?
it's a great
That's a,
option. It also, the DMV has their own small estates affidavit. If you're just dealing with a couple cars, no other real assets, you can use their form small estate affidavit to just get it to deal with lower estates. Right? There's not a lot of money, but they have a couple things.
and so
That is
you
somewhat unregulated. The court is not involved at all. So it's just a form that you fill out and provide to the financial institution or the DMV to deal with the smaller assets.
So if I were, uh, let's say I'm the person either in the will or I'm the person who's supposed to inherit under this intestate law, and then what I kind of look at what's the totality of the value of what I'm inheriting, and then I can make a decision without having to go to court to, yeah, it's within that range under the statute that I can use this small estate form and just fill it out. Is that
Yep.
right?
That's easy. And we assist people with that just to let them know, hey, because you can't, one of the frustrating things that people have with probate is when somebody dies, you really are super restricted as to access to information or assets, right? Like they're often like, well, I got to pay the mortgage. Well, I don't have the money, right? So it's frustrating at times for people because you just can't do much, right? The law in Colorado is that you can't even file to open probate until 120 hours have expired. after the death of somebody. So 5 days. So I like to call it like a mourning period where it's like, hey, just deal with losing your loved one. We don't need to race to the court steps, right? It will all be there to get processed in due time anyway. But if there is a need for probate, there's either informal probate, which is an example of you have a self-proving will that everybody can follow, or intestate, where everybody agrees who's going to get what, right? Or who's going to be in charge and there's no contesting it. If you have like a copy of a will, you have to go through formal probate because there is a question of the validity of the original will. Was it destroyed, right? Did they take some action to destroy it? That's why you can't find the original. Then you're going through formal probate, which is the simplest way to explain is there's just some more obstacles and steps. It makes it a little bit harder, but it's not the end of the world stuff. But you're, again, like we talked earlier, is you're giving notice to the potential, the devisees in the will, if you're looking at a will, to see if anybody would object and say it's valid or not valid.
So the starting point is maybe the net assets will allow you just to do this by affidavit.
Yeah.
And if not, if there's assets that exceed the $84,000, but also what if you own a home, if that person who died owned a home, you got to go to probate, right?
Yeah, you have to do probate no matter what, even if the value of the land, let's say if it was just some vacant land that was under $84,000, you'd have to do the probate because you got to transfer title, right? A lot of the probate is to keep good title on property, whereas the personal representative would then sign any deeds. It's a personal representative's deed normally to transfer ownership from the estate to whoever's next, like the buyer or anything like that.
So you start, hey, if there's no house or property involved, I can look to see if this small estate affidavit will work. And if that's not the case, if you have a good solid will that's been done correctly, and you have everybody agreeing that under the intestate statute a certain person is eligible, then this informal probate. What's involved with informal probate? Like, what does that process look like? How long does it take?
It's relatively quickly, I think, and I think people hear probate can be bad, but the reality is, in an informal probate, we can have somebody appointed in a matter of days.
Oh, wow.
So it's filing it, getting notice, and then informal, you're basically getting appointed, and then you tell everybody after the fact, right? If you're the surviving spouse, you have the priority. You get appointed, and then you file what's called an information of appointment, which is just telling everybody, excuse me, telling everybody that is an interested person in the estate, you've been appointed and you're going to move forward from there. That's when normally you also do the creditor period. You publish the notice to creditors in a paper in the county to give notice to anyone that this person is passed, and that's how you deal with any claims that may exist.
Okay. And then more formal probate is if you have there's a question about whether the will is valid, or if there's a dispute amongst survivors under the intestate statute as to who gets what. Is that right? Then you go more formal.
100%. Yeah. There's just a question of, like, there may be 4 siblings and they're all going to inherit, but they can't agree who's going to serve, right? So they may object to the appointment of my brother because I want to serve. I don't want him to serve, So then you'll get into some litigation just on that issue. I think what's interesting about this area of law is you can have one estate, right? Somebody dies, but you can have lots of disputes in an estate, right? Who's going to be the personal representative? An accounting issue. Did assets pass different ways? Distributions, right? Removal action saying the PR is not doing their job. All of those things can be unique. So there can be lots of little battles in one estate. Whereas in, like, your world, you may have a car accident and everything is related to just that car accident. Yeah. In an estate, we have lots of little things that can happen.
Wow. And let me go through another issue that I hear all the time. Let's say somebody is injured and they run up a bunch of medical bills, and they end up dying from those injuries. And the people either in the will, or if there's no will, the people who are going to be inherit the estate, they say to me, am I now on the hook personally? Is this going to affect my credit? Am I personally on the hook for all of these medical expenses or for the mortgage payment? Am I personally responsible? Can you just walk through, I think, what is a pretty relieving answer to families about that?
Yeah, there is no liability for anybody for what's owed, right? Um, you're serving as almost like an agent. Um, you're serving as a fiduciary for that person acting on behalf of the estate. So at no point are you doing anything to personally take over any debts or creditors or liabilities that the decedent may have. That's what I said. The creditor period is important. I tell people normally, like credit cards are a good example. You just provide them with a copy of the death certificate and they will negotiate a lower amount, or sometimes they may just go away, right? The only bills we tell clients to pay while the creditor period is going on are secured assets. So like a car, if there's a if there's a loan on the car, you want to pay it so that you don't have late fees or a potential for repossession. Same thing on a house, right? It's a secured asset, so there's something that can happen if you don't pay the bills. So we try to tell people, make sure you pay those. Anything else, you just wait for the creditor period to know how many claims you do have, so you can figure out what we can pay or who not, right? That's an important piece. Is you just don't know what asset you don't know yet what assets you have and how much you have to pay each creditor.
And so on the secured, uh, you know, creditor issue, the reason that you're telling people to go ahead and pay the mortgage payment is, well, one, if you're living in the house, you need a place to live, right? Two, if you're going to inherit the house, you don't want the house to go into foreclosure where all of these expenses run up and it starts cutting into what your inheritance might be, right?
Yeah, you're just losing money at that point, right? Like late fees, foreclosure fees, attorney fees on a house. I tell people to keep track. If you need to loan money to the estate, because a fair amount of the estates that we deal with are really based on real property. Like in Colorado, we're very lucky that real property has done well. Mom, dad, grandma could have just owned a house in Wash Park and didn't have much else, but that house now, where she paid $100,000 for it 30, 40 years ago, now is worth $1 million. So they may not have a lot of money to pay to help like fund an estate, but they're doing it because they got to deal with the house. So you may just have to loan some money. You just keep track of it, right? Create a ledger that says, here's what I've paid, why, how, so that you can show at least your siblings or whoever else are interested persons in the estate what the money was used for, and you can then just
That
replenish yourself.
Yeah, I mean that's super important stuff. And on the credit card front, um, I think in my mom's case, for example, she had a credit card, had a small balance on it. We had to send out. She did have property. We did have to go to probate. We sent a notice out to the credit card company. They never responded, and eventually we didn't have to, even though it was a small amount and her estate could have afforded it, we didn't have to pay that back at all. And we were advised, don't pay it.
Yeah. That's what I tell people. Like of all credit card companies, right? They get enough from us. You just like tell them, hey, we're waiting for the creditor period, and then you can and at worst, you can negotiate them down. So that's something we work with clients often with to make sure they get those handled.
Well, and so tell me about um, minor children in this setting. Uh, what happens with minor children if somebody doesn't have a will, and how does that get their financial future get taken care of?
Yeah, like we said, if there's no will, then they're going to, and if they're minor and they're under 21, Colorado considers minor under 21. You're going to have to do the conservatorship that I set up, as talked about earlier, that the personal representative or someone else that may want to help take care of the minor would have to file in the county that the minor resides to set up a conservatorship, which is similar to a power of attorney, a financial power of attorney. Is that money, any money they would inherit, would be paid to the conservatorship. So it's protected for that child until they turn 21. And a lot of times, let's just say parents were divorced, one parent died, the kid inherited the other, the deceased parent's money. The court wants to protect that money for the children until they're 21. And you and I've had some cases whereas the surviving parent, we may want to use the money for like school education, computers, right? The court sometimes drives a hard line to say some of those expenses are yours as a parent. You can't use the kid's inheritance to pay for things that you as a parent should have to pay for. So you can ask the court to use some of it. Sometimes you get away with it, like a car. They may need a car for things, or they may ask for private school or college. So, the court understands sometimes that maybe the parent just can't afford to pay for the kind of college that the kid wants. So you in those situations, you would ask the court to get an order to say it's okay to use the conservatorship funds for certain things, whatever that child or that minor may need. Then at 21, all that minor has to do is go into the court, show them his ID, state they're 21, and they'll just give them the money. So that's good and bad. That's why wills tend to be a little bit better, because you can do some planning in your will to say what I want to happen with my kids' money if they are minors, right? Like I talked about the 25, 30, 35, things like that.
Yeah. And what's the difference between a will and a trust?
A trust is its own entity. So the success factor when you do your estate planning to create trusts is to take your assets and title them in the name of the trust. So let's just say there's the Aaron Evans Trust. My house would go into that trust. My cars would go into that trust. So if and when I pass, that entity continues on, whereas I'm not the settlor, I'm not the trustee anymore. Let's say my wife would be. So she immediately gains control and access to anything that's in the name of the trust. The
Does
mistake
you have to go
people
to
make,
probate court for that?
you,
Probate
you,
court?
you don't. It's private. So that's one of the nice things about doing a trust is it continues on. Think of it like its own corporation, right? You don't need to have anything, because the trust will say who's the successor trustee. So if I had a bank account at Chase in my name of my trust, as soon as they get notification that I've passed, my wife would become the successor trustee and have access to all of those things. One thing that's important, Kyle, I think to know is too, um, it also helps when someone gets sick. So if someone ends up having bad dementia, let's say, and they can't make decisions anymore, the trust allows, with a doctor writing a letter to say that I've lost the capacity to make these decisions, that successor trustee then takes over control of my trust, in the sense that I can't mentally, I don't have the ability to make those decisions and control those assets. Whereas if it happens otherwise, you're filing for a guardianship conservatorship in probate court. So, and the difference between those two is a conservatorship is somebody that's managing your assets, right? Financial decisions for you. And a guardian is someone making medical decisions, like a medical power of attorney, taking you to the doctor, deciding where you live. Uh, they handle all of those decisions.
And now, I mean, it sounds like the trust is the way to go if you can, right? Because then you can uh, maybe avoid going to probate. It lays out what your desires are. You get immediate. It sounds like immediate access to be able to continue in absence of the individual who died.
Yeah, I mean, it definitely makes things easier for everybody, right? You don't have to wait the 5 days. You don't have to wait to get appointed. The personal representative, it doesn't have to go track down all these assets. They have basically immediate access and control of all of the assets that are in the trust. Like I said, and I'll drive this point home again, the important thing for anyone doing a trust is to what we call fund the trust, which is to make sure your assets are in the name of the trust. A lot of times people just forget an asset or something like that. Um, and then you got to go back through probate to just deal with that asset anyway.
Can you give me an example, like a tangible example of what you mean by making sure that the assets are in the trust?
Yeah, like the title to your house. That you'd have to do a deed to transfer it from your and your spouse's name, let's say, into the name of the Aaron Evans Trust. So that trust becomes that entity. So the new deed would say owned by the Aaron Evans Trust. The same thing with bank accounts, or like you may have a Merrill Lynch, Charles Schwab investing account. You want to change that into the name of the trust. It's still under your own social security number because it's still your own asset. But it's just titled differently so that that trust continues on after somebody passes away.
So let me ask you this. In some of those accounts, like a bank account, you know how there could be a beneficiary? We can name a beneficiary to a bank account. Can
Yep.
you just name the trust as the beneficiary to the bank account? Or do you have to
No,
put that
the
doesn't work?
problem is you could, but the problem is then you'd have to go through probate to get it into the trust. So the trust only has control over assets that are in the name of the trust. I think you bring up a good point, and we can talk on this. Is other ways to avoid probate is by how you title a bank account. And I mean by that is you could have a payable on death or a transfer on death on any of your bank accounts or investment accounts. And that is telling that entity that if and when I die, here's who gets that money. So if I have a bank account and a checking and a savings at Chase, and I put a payable on death on those accounts, it's a contract basically with you, with the bank. That contract says, okay, I've died and these people get that money. So you're avoiding probate that way as well.
So how do you do that? The banks just have a document
Bank
that you
has a
can.
form that you sign and say, here's who I want to get this.
Wow.
Same thing as you can do with real estate. It's called a beneficiary deed. You can record that deed, and what that deed says is what ownership I have of any real property at my time of death goes to that person. There used to be things where people would add family members on property as like a joint owner. That creates some tax issues. You've given up ownership. If you have a mortgage, it may create an issue. Um, it also affects a free stepped up basis. When I die, like I used that Wash Park example, if somebody owned a house or bought a house for 100,000 and they sell it for $1 million, you get the value at your date of death, which is $1 million. So there's no capital gains tax on any of that. If you transfer title in a way to give like your son to try and get him ownership, then you've given up really 50% of value at some point. So you're losing that stepped up basis. A beneficiary deed is a way better process to give somebody an interest after you die, and you may sell it. If you sell it, then the beneficiary deed goes away because it only works when you die as to what you own the asset.
And how do you get one of those? How do you get this beneficiary deed?
A lawyer would have to help and do those deeds. And it's a pretty simple process so that that's on that property to say, when I die, this is who gets my house.
It's interesting. Now
Yeah.
there are some, and we're running short on time here, but I want to go over one other issue that I think is really important, and that is what's the difference between like a 401k and a life insurance policy where there's a beneficiary listed? What if there's a will? Because some people will come in and say, um, you know, there's a will and I'm the person who inherits everything according to the will, but the life insurance company is telling me somebody else is getting the money, and that doesn't seem fair. Can you describe why and how that happens?
Yeah, I mean, like we talked about that payable on death, transfer on death, life insurance, 401ks, IRAs, all of those tend to have a part of their process that when you set it up, that they ask you who you want to be your beneficiary. So it's a contract with that company, Fidelity, life insurance, all the same is that asset says who gets it. So, I often talk about this. Um, Second marriages can be a good example, whereas you may have a will that says everything goes to my kids from my first marriage, but the house that you own with your second wife or husband may be in joint tenancy with right of survivorship. So that asset goes to the joint owner. It doesn't matter what your will says. Life insurance has a named beneficiary. That would go to whoever you listed on that asset to get your life insurance, your 401k. Does not matter what your will says 99% of the time, because that's a contract that existed between you and that company. And that company has a document that says, here's who I get it. Here's who
So,
gets
so
that or
let
what
me,
percentage.
yeah, man, this is important stuff. Let me ask you this. So let's say I work for an employer, and the employer has a life insurance policy that pays like 1 year of my salary or something like that. And, 10 years ago, I put my current wife as the beneficiary. Somebody gets divorced, and they don't change the beneficiary on that life insurance policy, even though they're divorced from that person and they die. Does the first spouse that you named, even though you're divorced now, get that money?
It's unique in divorce, because there is a statute in Colorado that if you get divorced but you forget to sever assets in joint tenancy, like your house, we'll give an example. There's a statute that says you never intended for them to have that asset. You just
Okay.
made a mistake. But I will say this, when you deal with 401ks, IRAs, you're dealing with more federal regulations. That same statute will not apply. So you could have risk if you get divorced and you forget to make a change on who your beneficiary of your 401k or IRA, something like that. There is real risk that that person could inherit that asset.
Wow. Well,
Yeah.
just amazing stuff, man. I could talk to you for hours and hours about it. I mean, really, like all of the different kind of nooks and crannies and ways. But I tried to wrap up these podcasts with some basic life hack information, right? Based upon your knowledge and your skills and your years of experience, of your to impart knowledge to people to say like, hey, here's a couple of things that I see that, man, I just wish people would go out and take care of, because it's going to make a big difference. Well, I'm sure we have touched on some of those things, but can you just say what are the biggest things that you think people should do to make sure that what happens when they die happens that they want?
Yeah. Yes. I mean, I think the biggest life hacks really is getting a will, and it's as simple as writing it out yourself. It does not have to be this super legal thing. It's just to say, hey, here's what I want to happen when I die. Especially with minor children, because somebody's going to have to take care of those children if you both pass. And obviously that happens a fair amount from life itself, car accidents, what it may be. You put direction in your will, who's going to take care of my kids and what money can be used to help take care of my children. Another one is like we talked about, simple things: beneficiary deeds, payable on deaths, transfer on deaths. It's just a form that you can go down to your bank and fill out and say, this is who I want to have this asset. I really do encourage people in real world stuff on second marriages, because I think that can create a lot of disconnect between the second spouse and the children. And that can be hard on families if you make a mistake. So trying to know what your assets are and how they're titled is just something that you should really put a little bit of time in. Because the reality for most of us, even yourself and I included, is, we have a house, we have some bank accounts, we have investment accounts. It's not like we have 70 accounts anymore,
Yeah.
right? So it's not that hard to just get control of what you have and have all the things in place and be aware of it, and write it out a little bit. Like I said, have that attachment that you give to people to say, here's my Facebook password, Instagram, my bank accounts, right? Here's the email code to get access to it. That really helps the family after getting control of things and being able to do the things that they need to do. Pictures, like you said, that's very important, especially for funeral arrangements, all those things. But those are things that if they have immediate access and control, their life is that much easier. And it's hard enough losing somebody, but having to deal with it and having to go find other things that you just can't get control of is that much harder.
Hey, and if people have more questions that they'd like to ask you specifically about their lives, how you might be able to assist them, or your team of lawyers can assist them, what's the best way for them to be able to find you?
Yeah, obviously our website, evanscase.com. My email is evans@evanscase.com, very simple. Or our phone number is 303-757-8300. We give free consults. We try and answer as many questions as we can for people. I mean, it's like you and I talk about knowing each other well. The reason I'm in this business is to help people.
That's
I
right.
enjoy it. I try and get them through the probate process as quickly, as easily as we can. we try and find solutions for people and help them problem solve this stuff to make it easier on the probate side, because they're dealing with loss of someone that mattered to them. That's hard enough. Helping navigate the probate process and making it easy on them, something we take a lot of pride in.
Well, I really, really, really appreciate it. We are honored, honestly, to have you, and appreciate your time this afternoon. Thank you, thank you, thank you. I look forward to seeing you in person real soon.
Yeah, for sure.
So I just really appreciate your time today. It's been just an incredible hour to spend with you. So thank you so much.
Of course, happy to help. Always answer questions and to help people with just give them an idea what is easier as they move ahead with stuff.
So again, guys, this is your host, Kyle Bachus, at the Unthinkable podcast. So happy that you were able to join us. I'm sure today you learned a lot that you can apply to your own life, and also some interesting information that hopefully you never have to use in an emergency situation. But I hope you did learn something today. I think you did, and we'll see you next time. Until then, please be safe out there.
You've been tuning into the Unthinkable podcast with your host, Kyle Bachus. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, kylebachus.com. Thank you for your positive reviews, comments, questions, and for sharing this show with others.